With that said, does the state wish to present anything?
Yes, Judge. May I approach with some copies of the handouts for you and for yes? All right, Judge, as I mentioned, for time purposes, because we know the time is limited, we will not be calling witnesses, but we will be sharing exhibits that were part of discovery, also shared with defense counsel. And I'm going to go through them one of each of the charges at a time. So, Judge, when I'm done, the state will have spoken on all three of these matters. I know we have two different defense counsels. I know you have different findings you have to make, but for purposes of brevity and efficiency, we're going to walk through all three. The first one is the manslaughter conviction, Judge, which, as you know, is 290304. B, the court can choose between 9, 12, 18, 24, 30, and 36 months. The court knows that. But the court may not know some of the evidence of the case, and as a result, I'm going to share some of that with you now. Much of this, Judge, you will recall from the previous presentation the state made in the co-defendant. And so although we don't have to say by judicial notice, that we can say that several of these things you already know. There was an extremely vicious dog in the house where the defendant and the mother of the child were living. You saw some footage, Judge, of the capture of that dog and how aggressive and vicious this dog was. I'm not going to play it again because you saw it for one time. Again, trying to be efficient with our time, Judge. You had access to the photos of the horrific incidents of the child. I'm not going to put them up. The court had access to that. Just noting for the record, these were heinous, heinous injuries to this baby. One of the questions, of course, is whether the defendant knew that this dog had a history of being aggressive, because if he did, that makes the culpability much more serious. What you're seeing now is body cam footage from a jail interview with one of the investigators in this case with the defendant, who, just because of the angle of the sitting, we can see the left hand side of the defendant, but it's clearly the defendant. And the question that's being asked is whether or not there was a history of this dog. It was called Kilo, a Pitbull mix. Whether there was a history of this dog being aggressive. And I'll make sure we can hear the volume, but this is what the defendant said.
Is that right? Okay. Was there a history of this dog being aggressive, or?
No, that's what we didn't understand. Everything was fine. We haven't had really problems with it.
Was the dog aggressive? No. Now, haven't had problems with it. We didn't understand. That's the story that the defendant gave to this investigator. Then the investigator asked a question about whether his grandmother had said, you know, did your grandmother tell you there was a problem with this dog and around children? The investigator had reason to believe that had happened, but the question was put directly to the defendant, and you'll see his answer.
How about is Audrey, that's your grandmother? Okay. I talked to her, and she said that prior to this incident, she's been begging you guys to get rid of the dog for a long time because it was aggressive, and
she just don't like the dog because it barks when people come at the door. And
she said that there had been several incidents prior to where it had tried to bite you, or I think the word she used was snipped at you.
Snipped at me?
Yeah.
I don't remember that.
You don't remember anything like that?
No.
Okay.
No. She's kind of dramatic with the dog. She's kind of like dogs.
She's just not a dog person.
Yeah. Knowing what we know, impression on behalf of this grandmother, this was, of course, false. The defendant knew very well that this pit bull called Kilo had not just been dangerous around the house, where the grandmother would have seen dangerous around the house, but dangerous to other children in the neighborhood. Your Honor will recall we played a 911 tape in our last sentencing, where a mother in the neighborhood was reporting that this pit bull mix had come out and tried to attack her child, tried to bite the child, wound up injuring the child, not by a bite, but apparently part of the clothing protected the child. And you also remember, Judge, we played for you some body cam footage from the officer who responded, where the mother not only told about what happened to the child, but played video of it off her own phone. So again, for efficiency purposes, Judge, we will remind you that was played before. What we didn't play before, well, I'm sorry, one more thing we did play before, Judge, is then, of course, the dog warden went out and talked to both defendants. You can see them in the screenshot from this image, and specifically said, your dog tried to attack a neighborhood child. You need to be cautious and careful with this dog around children. We played that clip for you, Judge. You remember that warning was made. It was made to both defendants on that day. this is the scene. I'm going to, before I go to a judge, there was no, the victim is nowhere in the scene. This is simply the scene afterwards. The victim is on his way to the hospital where he will be pronounced dead. But we're now going to hear that, in fact, that when this horrible thing happened, when this pit bull did attack and kill this infant, that the defendant is acknowledging at the moment that he knew he should have done something with this dog before this happened. Because remember, the story to law enforcement was, we had no reason to believe this. Grandmother, she's over dramatic. There's absolutely no reason. He's warned by the dog warden, warned by the grandmother. Now that the horrible thing has happened, Judge, here's what he says.
The couch is fine. I went to pick him up.
Yes.
It's my fault. It is not your fault.
He's on his knees crying, screaming out, "It's my fault." That's not the only thing, Judge.
Listen to me. Listen.
It's hard to understand. I played it several times. I believe the transcript is accurate. We should have gotten rid of him a long time ago. This, of course, suggests that he's acknowledging in an excited utterance, which, as you know, Judge, is more credible than other things said when you've had time to prepare what you're going to say to investigators. He's saying something that we should have gotten rid of a long time ago. Later at the hospital, after the child has been pronounced dead, investigators continue to talk to both defendants, and this was said to the investigator during that time in the hospital hallway.
I just need one of you guys to sign the dog over, and I'm taking it. You guys, I'm sure you don't want it back, ashes or anything like
That
that.
was my dog. I already know you're going to start hating me now because this is my dog.
I just
already
didn't want
see
to sign
it.
it because it's...
So, to the mother of the child, yes, that was my dog, and you're going to start hating me now because it was my dog. Further acknowledgement of the two defendants with respect for responsibility for the dog. This defendant has a greater responsibility for this dog than the other defendant.
You did everything we...
No, bro. I've seen he's getting angry at me like that. I should have got rid of him earlier.
Same location, hospital hallway, signing some paperwork about the dog. I'd seen this Kilo, was getting angry and mean like that. I is the past tense, so I had noticed that in the past, and I should have asked that, could have gotten rid of him earlier than that. Further evidence of the facts that the defendant was lying to investigators when he said he didn't know this dog was vicious. These excited utterances at the scene of the crime and later at the hospital show that he in fact knew these dogs were, this dog was vicious. There were other dogs in the house, they were downstairs. That's the overview, Judge, that we wanted you to see with respect to the dog portion of this case. In this case, it's the involuntary manslaughter. I think you were already familiar with a lot of it. This other evidence I'm about to play on this next charge, you may be less familiar with. This is the escape conviction, Judge. 29-21-34, as you know, it's an F3, and you can sentence 9, 12, 18, 24, 30, or 36 months. The defendant is in custody, and he's being arraigned or some sort of judicial proceeding for this matter over in the city building, which, as Your Honor knows, that there's a municipal court. I'm now putting on the screen the footage from the security cameras where he and a couple other prisoners are coming down the steps from municipal court. You're going to see them come down here in a moment at the top right. The first prisoner is the defendant, and he's ahead of the other defendants, and he's ahead of the deputy or the officer who's responsible for watching him and moving them back to where they were being held. You may be familiar with the layout, Judge. We're now moving down to the ground floor of the police station. There's a back door there. The first person out the back door, right there is the defendant. That's the center one. And then on the right-hand side, Judge, is the shot of the parking lot just outside the back door of that building. I'm going to zoom in now in this next frame. Here goes the defendant. Off he goes. Running, escaping from custody. This is not a hearing about whether it's a smart thing to run in an orange jumpsuit while shackled at your waist off into the snowy parts of the city of Marion. But all of the officers that were put on immediate alert to go search for him, he's now out amongst the population of the city of Marion, obviously desperate, obviously not making rational decisions, no idea what he's going to do to the people he may encounter. He didn't run into a government parking lot. He ran into a private home area and one officer is going to find him, and so this next clip is from that officer's body cam, where you will see he is found between two private citizens' homes in the city of Marion.
I got him here. I
You have to pull his gun.
Get on the ground! Get on your stomach. I got him on, Noonan. I got him. Right there.
I know.
Okay, so Judge, we saw the crime, the escape, and we saw the arrest from the crime. It's pretty obvious, not much more to say about the escape, other than he's literally trying to escape responsibility for what happened in this case. It's going to be a theme, Judge. Moving to the third charge, which is the strangulation charge, Judge, and we've covered the manslaughter case, showed you some of the footage from that to give you a sense of the equities of that matter, showed you the escape case, pretty straightforward. Now the third one is the strangulation case, Judge. Under 290318, it's an F4 strangulation. There's different levels of strangulation. Your Honor probably knows Ohio was the last state to make strangulation a felony. Just a couple years ago, the General Assembly made it a felony offense. It could be an F2, it could be an F3, it could be an F4. This is an F4. This is the one the defense counsel and I discussed to make sure we have the accurate recommendation on there, but you can see all the possible sentencing ranges for you. This comes about from an encounter with this defendant and the mother of the baby who was killed, Alyssa Smith, at the home where that happened some months later. This is January 20th last year, and you'll see here on the screen, Judge, that the officer, after being told, and you're going to see a clip here in a moment from the body camera, being told by Ms. Smith that the defendant had strangled her, the officer asked her if she had any visible injuries. And then, Judge, if you look, you can see that there is a red mark here on the neck. Over the weekend, Judge, I was taking a CLE on strangulation, keeping up with my credits. And you probably know, Judge, because you've had this training at judicial school, that the slightest amount of pressure on a human's neck, even one that wouldn't create a mark, is enough to meet the statute and certainly enough to cause damage with loss of breath. So you're now going to see body cam of the investigating officer talking to Ms. Smith about whether or not she was choked in an altercation between Blake Bates and Ms. Smith at the same house where the baby died. Here's the relevant portion, Judge.
Came out.
Okay.
So I left. I shouldn't have to leave my home, but I did to try to solve all this. I come home today, he wouldn't leave me alone, he kept going and going and going. He took my phone. I did go after him. I said, you know what, that's my phone, you know, I use it for work, like I need my phone. He swears up and down I was cheating on him, blah, blah, blah. He has insecurities, whatever, whatever. My grandma calls me, I answer it. I tell him, just, you know, just go. Before it gets worse, just freaking leave. So I was on the phone with my grandma. He ended up choking me up. He ended up throwing me on the freaking clothes in there.
Did you look up for him?
I don't know if there was anything, but he did. It was just for a quick second. Then he freaking slammed me on the ground and everything else. My grandma basically hung up with me and called you guys.
Okay. You said he was choking you up. Did it restrict your airway?
Yes.
It did? Like
yes.
It changed the pattern of your breathing?
Yes, and this isn't the first time. This is just the first time that I'm fed up with it and I'm done.
Okay. And then...
What she's describing, of course, meets the definition of strangulation, and she gave a little bit of context surrounding how that came to be. He's not arrested at this house, Judge, because just like he was trying to escape responsibility for the manslaughter case, just like he was trying to escape literally from the court building where the judicial proceedings were moving forward, he will now try to escape from this crime scene and runs into another neighborhood to a house that was tipped off the police he might be hiding at. That's this footage here. You will see he's hiding from the police in a rather cluttered garage of one of these houses nearby. Police once again are having to take great caution to confront a potentially desperate fugitive, and they have to have the canine dog go in to find him. And this will be the footage of the canine dog discovering him in hiding as he tried to escape responsibility from the felony strangulation he had just conducted.
Okay, Hey, come out now! Show me your hand! Show me your hand! Come out! Come out now!
Come out. Come out.
Keep your hands up or you will get paid. Do you understand?
Yes, sir.
Come out with your hands up. You are under arrest.
Okay. Yes, sir.
Do not reach for anything.
I'm not.
Get up slowly. Get up slowly. Get up slowly.
I see.
Put your hands up. Hands on your head. Hands on your head. On your head. Step over towards me. On your head. Alright, hands behind your back. Put together. Yeah, lights on.
So, I'm a warrant, but I'm in trouble with what?
I'm gonna let this play, Judge, because they're gonna go out asking
I'm aware
questions
of time.
about the squad car. So give it a moment. They're gonna walk him out.
You don't hear our commands?
Questions.
Huh? No, I'm just freaking out, dude. I'm just being.
What are you freaking out about?
And me and my girl got in a fucking fight.
You're the right term in time. I think you say, you
And I just shut up. I showed her like.
Hey.
I'd like to talk to her and have him represent through questions. Can I afford to hire a lawyer, one to be one representative for any questions you wish? Please stop answering our questions at any time. You understand your rights?
Yes, sir.
Obviously, you're already saying why we're here.
Well, I just heard.
What
I
happened?
heard a warrant and I heard something else, so I asked.
What happened between you and your wife?
Found out.
Can't go way out.
Sorry. Found out she cheated on me again, sent like $1,700 to a guy in jail, and
Okay.
I took her phone, and when I took her phone, she got every grand and shit, and hit me with this, like, I don't know what it was, it don't matter. I got like shoved my way through where she got around me.
Shoved your way through and you
Yeah,
fell?
yeah. God had it. Yeah, so. Even though I was down there.
Man, 4 people had your back on that one.
Don't do that. Just because I went out back.
When they get out to the car, Judge, they're gonna ask him if he has anything in the pockets that they need to know about. Anything alive.
I appreciate it. Thank you. Okay. Well, we got what we needed.
Alright. If you guys can just get names of witnesses.
This is the relevant part here.
So, can I ask what was followed, like, or like what I'm getting charged with, or?
Honestly, I don't know. I'm not the investigating officer. I just came to help because I knew that you were here and you had a warrant. So, here.
The warrant's like what, misdemeanor or something?
Like, do you have anything on you need to know about before you go reaching
I
around?
don't think so.
No type of drugs?
No, I have just a couple lighters.
No type of weapons?
No.
Okay. Nothing else gonna
What do you
hurt
need
you?
to know about? No
Pretty
weapons.
positive I don't.
What's this?
I don't know, I just put these fucking on or take off running.
Wait, don't lie.
I'm just being honest, it's probably it's drugs, but I
What kind of
didn't
drug
know
would
what's
it
in
be?
here.
What kind of drug
Coke
would it
or
be?
something like that.
Coke?
Yeah.
I should.
He lied, said he didn't have anything he needed to know about. He said this.
That's all I was came to, you know what I mean?
He also said no weapons. Let's get the right pocket.
Okay, when I asked if you had any weapons, why didn't you tell me you had your...
I didn't even know they were in my. I'm so sorry. I didn't know they were in my
There's the rest.
backpack. I'm freaking out. Sorry, I'm not even thinking about it.
Continuing to lie to police, continuing to escape responsibility, trying to evade responsibility. Judge, you should also know that there's evidence that this defendant violated your protection order. You're familiar with the jail mail system where inmates can communicate with one another. One of your bond conditions was that this defendant does not communicate with the co-defendant in this case. And there were jail mail to Alyssa Smith under someone else's name.
Your Honor, I'm going to object at this time. I understand the court has the ability to consider whether bond violations are, in fact, it does have an impact on sentencing if he were to violate bond. I don't believe that there was a bond violation filed related to these messages. As such, if this is going to be subject to a consideration by the court, I think the defendant is subject, or would be, needs to be afforded the opportunity for there to be a cross-examination, for there to be a presentation of evidence directly related to this, and then the court to make a subsequent finding whether he did in fact violate his bond. There again, there is no bond violation filed, so I understand the effort of the prosecution here to spend 25 minutes on a joint recommendation at this point for at least 2 of the cases in an effort to paint Mr. Bates as a bad guy, but this I don't think is relevant for the court to consider at this point.
Well, I think, one, they can choose how they want to present evidence at a sentencing hearing. It's quite normal that we don't have testimony. It's quite normal somebody reads a letter, they tell their opinion. I think there's any other sentencing factor is relevant. I don't think he has to be found to have been a bond violator, to have been in violation of his bond. To his advantage, he didn't get probably charged or a BV, bond violation, because he was in jail. The point being, I mean, what bond violation is there going to be if he's in jail? What's the sanction? Don't do it anymore?
Well, Your Honor, I think that's exactly why the court, in bringing this up and the court considering it, it has nothing but a prejudicial effect without the appropriate administrative and procedural safeguards put in place to ensure that the defendant in this case actually did do these things. I understand it's alleged, and I think that's the problem, is that a sentencing factor, and specifically the ability to go to prison. I understand there's a joint rec here, so I think it's a little bit of a nonsense point that we're even arguing about it right now. I would just ask that the objection be noted in that he did not violate his bond pursuant to any finding made by this court.
Mr. Weaver.
Yeah, first of all, the judge, the state will put on the record, as part of the universal agreement in this case, the state will not be prosecuting as a separate charge the bond violation. So any due process concerns have been resolved by the fact I'm stating on the record we will not be bringing any additional charges related to this. Secondly, Judge, as Your Honor knows, that when it comes to your attention that your bond has been violated, it allows you, without any other due process, to make adjustments to bonds, which means there is a basis upon which a court can make some decisions based on a relevant fact. In this case, the statutory sentencing factors say that all other relevant information can be considered by the bench. I'm about to show you the video where he's going to acknowledge that he did this, violating your order. I'm simply starting with how it came to be, but in mere moments, Judge, in a very short clip, you're going to hear him acknowledging that he purposely and willfully violated your order. We think it's relevant.
Was this initially, joined for trial?
Was this joined for trial?
These were separated?
These were separated for trial.
Oh, yeah, there's cases, that's right, different trials.
I'm also got information that I can consider from Ms. Smith's hearing, which this was another issue there, but I'll go ahead, I'm going to overrule your objection. I'm going to have Mr. Weaver continue with his presentation, but I don't think he has to be found to be a formal bond violator, being violation of bond. My point is when you're out on bond, we can make adjustments to his bond. When he's in jail and he's violating a no contact order, I suppose I could say he can't have access to the computer. I mean,
well, and that's actually part of the problem, Your Honor, is that I don't think the bond is actually put into effect until he signs and acknowledges the OR bond or the PR bond that's part of the bond itself when it's posted. If a bond isn't posted and you've not acknowledged an OR bond, you are not necessarily subject to those bond conditions because the bond is not in effect.
Okay, well, there's a no contact order.
But if it's subject to the bond itself, it's not actually in effect. And that's, I think, part of the problem here in determining whether he did, in fact, violate his bond as alleged by the state.
There's a protection order in effect, correct?
I beg your pardon?
There was a protection order, so he's violating the protection order.
Out of the municipal court, though, and that's part of the problem. We are considering things that are not subject to this proceeding because they haven't been properly brought to allege the defendant has done these things. I understand the court's position absolutely that he can present his case, and I respect that. And I'm not trying to get too heated here, Judge. But this, I assume, is relating to the 2 cases which we have a joint rec for. So I'm also not sure what the dog and pony show here we're doing to talk about a joint rec. I just don't get I don't understand.
There's not a joint wreck involving Mr. Wick's case.
There's not, but
And it's all being sentenced at one time, and out of efficiency, we're doing it all at once. So I got your note. Do you have any more
Thank you.
comment on it?
No, Judge, thank you.
Thank you. Go ahead.
Again, I'm going to try to be brief, Judge. This is the jail mail from Zachary Schaffner to Alyssa Smith. That in, of course, you see references to Blakey, which is, there was some testimony at the previous sentencing hearing about code being used between this defendant and that defendant, but lest we have to guess whether or not this defendant did this, or lest we have to guess whether he knew that he was under this protection order, investigators came to the holding facility, asked him about it, and this is an exchange.
No breeze.
It is what it is. I ain't gonna lie about nothing.
So you're confirming these are messages between you and Alyssa Smith, correct?
Yeah.
Okay. So you were using Zachary Schaffner's email to contact Alyssa, correct? Okay. And then you used Matthew Henderson used him to create a three-way call with you and Alyssa, correct?
That's with Jessica.
The two?
Jessica.
What do you mean?
I've been talking to a girl named Jessica with Matt.
Okay. Have you used him to speak with Alyssa over the phone?
That was a long time ago.
A long time ago? Not last night or early this morning? You sure?
Yeah, I did.
You did? So this is you and Alyssa?
Yep.
Okay. Okay. So obviously you know there's a protection order between the two of you, right? Looks like you were served back in January on the protection order. Okay. You do have one prior protection order violation, which makes this one a felony. Okay. So obviously you're going to be charged for that.
How many it is? Like at 5 or...
We'll come to discussion of what degree it might be. As you know, Judge, I said the state will not be bringing it. The investigator did point to the fact there was a previous charge of violating a protection order that was filed in Marion Municipal Court. The facts here, Judge, are once again, he's trying to evade responsibility. He's trying to escape responsibility for all of these different charges, both the horrible death of his baby, the escape, and the strangulation. So he's admitted to them. That's why we're here today. The sentencing factors, as the state has put forward in its sentencing memo, pretty obvious here. You've gone through them. You know them. You do them in all the sentencing. Let's see if we can apply them as best as possible. We think they lean towards consecutive sentences in every situation, particularly when you look at 29-29-12, the seriousness and recidivism factors. The baby in this case certainly suffered serious physical harm. The baby was mauled to death by a Pitbull. That's something the judge has to take into consideration. It was the offender's relationship, this defendant's relationship as the father of this baby, the person, perhaps the most important person in the world to protect this baby from danger, actually brought this dog, which we already showed you he knew this dog was dangerous, brought and kept the dog and other Pitbull type dogs in the house as well. That facilitated the offense. That's obvious. And then when you look at those that might make this less serious for purposes of sentencing and recidivism, it appears that these things do not apply. Defense counsel can argue their case. We think they do not apply. Higher likelihood of recidivism. There are some key things here. He's previously had some minor level criminal offenses as outlined in the PSI. We don't think he's shown remorse, Judge. I'll let you make the ultimate decision on whether he's shown genuine remorse. Certainly as being talked to by the investigator about what happened, lying that he had no knowledge that this dog was aggressive, tends to make one think that there's no remorse here. And we will allow you to apply the lower likelihood of recidivism. We don't think they are applicable. Once again, defense counsel can make that argument. So we talked about the other relevant factors under 29-29-12, and we presented them. This is the recommendation, and this does reflect the accurate count after we made the Scrivener's error update that we discussed at the beginning of the hearing. State recommends 36 months on the manslaughter, 8 months on the F4 strangulation, and then 12 months on the F3 escape to be run consecutively with one another. Judge, we think that is the only way to get justice in this case. If and when this defendant gets out, we also think to the extent that the judge has the ability to, this defendant should not be able to own dogs of any sort ever again. The notion that he would continue to keep dogs in the house after what happened and then deny responsibility is one that, whatever your sentence is, Judge, we think you should include that as part of your order. That's the conclusion of the state's case. Thank you, Judge.
All right, Mr. Van Bibber, anything you want me to know regarding the two relevant cases that you're handling?
Well, Your Honor, I'm going to briefly just touch on the last portion. I understand that the dog bite case is separate, is separate from the strangulation and the escape case. But there was a condition that was requested that he never be allowed to own dogs again. I don't think that's within the purview of this court to be able to do that, and given that we're just sentencing together, I would note an objection as it relates to any disposition of the two cases that I'm addressing. That being said, Your Honor, I would also again note that there was a joint recommendation in these matters in the, 7-ish years that I've practiced and the 10 years before that that I've been a part of the legal field. I've never in my entire life seen and I will say it was a very nice presentation, and I do appreciate the walking through it, but the vast majority of this really tries to utilize the strangulation and the escape convictions, which he has taken. He pled to the indictment. He pled to the charges that were brought by the state. There was a joint recommendation for them, sure. And there was some knowledge charges, if I recall correctly, domestic violence that was taken off of that. But the escape was the escape. He pled directly to that. And there was a joint recommendation, again, as it relates to the disposition of the matter. But that's normal plea bargaining. Your Honor's been a part of prior to taking the bench and then disposing of cases since you have. Probably thousands of those. That's how we get cases resolved. And so because of that, I find it somewhat disingenuous to say that because when speaking to the police or when being investigated for other crimes, he may not have been forthcoming with the officers at that time. He was also doing that without the advice of counsel, without being placed under oath. So the Supreme Court has made time and time again statements regarding how we are to perceive individual statements. Specifically when they are addressing a court or a tribunal, how they are when they are addressing the officers in the everyday field, or when they are put under oath and things like that. It is a different standard that we are to utilize. Sure, he should be forthcoming and honest, and the PSI notes that as it relates specifically to the two cases that I'm talking about here today. So I'm not going to belabor the point, Your Honor, other than to ask that the court hold the state and the defense to the joint recommendation that has been made. I do not think that the dog bite situation, I think that the timeline of events, which the court is familiar with, I think if we look at that, the state had full knowledge of all of these factors, all of these circumstances, when they offered the joint plea. And I think that the ability of the state and the defense to come together and make a joint recommendation to the court should be adopted as it relates to case number 2025 CR 42 and 2025 CR 80. I greatly appreciate the court's time, and I do believe my client does want to make a statement regarding this case, but I think we're going to do that together after Mr. Wick has an opportunity.
And we'll probably do that after the victim's statement? I
Yeah,
probably should have maybe done that already.
The victims do want to speak, and I want you to put that wherever you want to appropriate. The state's done with its portion, and wherever you decide the victim should speak, that's fine.
I probably should have done it after you. I'm going to do it after Mr. Wick, and then Mr. Bates can, unless you want.
No, I prefer Mr. Bates to just have the opportunity to kind of close everything out if we could.
Mr. Wick, you have anything you want me to know about Mr. Bates?
Your Honor, I think first and foremost is the fact that my client lost his son. And I think that plays very much into what the state wants to talk about as far as statements made about this dog. I think that any parent, when faced with the situation that Mr. Bates faced that day, the loss of a son, he as a parent acknowledged, I'm a parent. I take responsibility for it. I don't think it's the responsibility to say that I had a vicious dog, but that I had the responsibility to protect my child. I think it's also critical in the court sentencing of my client that the facts of that day are very clear, and that is my client was with the mother of this child, and the child, he then left the child in the company and in the protection of mother to go downstairs. They'd recently moved into this residence. He was downstairs cleaning out boxes. When he left, the child was with mother as a form of protection. My understanding is the mother has given 3 different versions of what took place during this actual confrontation between the child and the dog, whether mother was even present. This is not something that my client had any control over in the incident involved. I think the court needs to look at that and the fact that my client left the child in the company of the other parent in this case. We also have the situation in the sentencing memorandum where the state says that my client ignored explicit warnings. The only warning he was given at the time of this alleged incident with his prior neighbor was not to let the dog run. And I think that the facts, as the state is aware, my client said, I was letting the dog out. There's a leash right by the door. The dog got out. The child was not attacked. The child had a scratch which mother presumed was the result of this dog. But that's the only contact between law enforcement or dog warden and my client. So I think it's a misstatement to say that he ignored explicit warnings. This dog was such that he had the dog. The statements that were made relative to aggressiveness were made at a time when his son was dying or potentially dead. I think also the state, in their sentencing memorandum, wants to make the allegation that the dog's name, Kilo, implies some sort of drug usage by my client. It's interesting, when I just Googled the name Kilo, it came up as an African name used to talk about first in chief. It also Google went on to say that Kilo is now a popular name for dogs, as it implies strong, dependable, protector, and legal. It also references Kilo Ren, which is a Star Wars character. So I think that that's an attempt by the state to muddy the waters that has no real effect on the sentencing of this case. I think the court also has to take into consideration that while my client was charged with manslaughter as a felony of the first degree, the state did not pursue that to trial. Now, I know the court can take into consideration charges that are reduced or dismissed. However, in this case, Your Honor, the state couldn't prove the F1 manslaughter charge. He pled to an F3 manslaughter, which talks about as a result of a misdemeanor child endangerment case. I think that's critical in this. This individual has no prior felony offenses. It doesn't take into account those dismissed charges. Now, my client at the change of plea hearing admitted his responsibility as an adult and as an owner of this dog and as a parent. However, I don't think the court can lose sight of the fact that my client lost a child, and I think that needs to be taken into consideration when the court looks at sentencing. I think specifically the punishment factors is that my client has in fact lost his son. My client has spent a considerable amount of time incarcerated. I think that will not demean the seriousness of this offense. Initially, Your Honor, if it weren't for these other 2 charges, that there was a joint recommendation that I was not part of, I'd be asking for community control in this case, Your Honor. And I think that the seriousness of this offense would not be demeaned by the fact that my client be given community control to ensure that similar ownership of animals is not taken into consideration. I would ask, though, now that the defendant has entered into a negotiated plea on his other pending charges, that this offense be run concurrent as to the other 2 charges, Your Honor. I think that my client serving the 20 months on these offenses, or on these other offenses, is sufficient enough, given my client's involvement in this case, and specifically the acknowledgement of wrongdoing, the taking responsibility for it, and the fact that my client is a victim in and of himself, having lost a child, Your Honor. Thank you.